So we need to talk about a recent 9-0 unanimous ruling that was issued by the Supreme Court involving the Fourth Amendment's protections and when excessive force by law enforcement impacts that right. The Fifth Circuit issued a new ruling in light of what the Supreme Court said, but after the Fifth Circuit issued that ruling and potentially it went against the Supreme Court, this case then found its way back in front of the Supreme Court on an emergency basis. But now we have the official denial by the Supreme Court actually upholding the Fifth Circuit ruling. So we need to talk about what happened and what this means for Fourth Amendment rights going forward. Now, before we jump into this video, if you like this type of content and you want to make sure you get it going forward, make sure you like the video, subscribe, and turn on all notifications to ensure you never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. Now, as I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous decision that was issued by the Supreme Court. This case involved the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force impact those rights. This unanimous ruling came in a case called Barnes versus Felix, and this case was already back in front of the Supreme Court for re-review just months after the Supreme Court issued that unanimous ruling. That was because the Fifth Circuit issued a new decision in light of that Supreme Court's 9-0 ruling. The Fifth Circuit once again ruled that the officer's actions were in fact protected even under the totality of the circumstances approach, and the en banc panel recently denied review to the case. The Fifth Circuit engaged in some very interesting review of the case after the Supreme Court decision, which had now then teed up the case to go back to the Supreme Court for reconsideration once again. Now, the facts of this case are very interesting. You had an officer, Roberto Felix Jr., who pulled over an individual, Ashton Barnes, for suspected toll violations. I believe that the individual here was driving potentially a rental car that had some toll violations, and a camera picked up the vehicle and the toll violations, and so he was pulled over. Now, after pulling over the car, the officer ordered Barnes to exit the vehicle, but unfortunately, in making a horrible decision, Barnes pretended to open the door, acted as if he was going to exit the car, but then he attempted to drive away. Reacting in a split second, the officer there then decided to jump onto the ledge of the moving vehicle. So he kind of jumped onto the open door ledge as the vehicle was driving away. He then pulled his sidearm and fired 2 shots at Ashton Barnes, who he was struck and he was fatally wounded, and eventually the car was stopped. Now, in response to this incident, Barnes' mother sued the officer on behalf of her son, alleging that the officer violated Barnes' Fourth Amendment right against excessive force. Now, the district court granted summary judgment in favor of the officer, applying the Fifth Circuit's moment of threat rule that was controlling precedent at the time. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. So under that rule, events that lead up to the shooting are not relevant at all and should not be considered. This case made its way all the way to the United States Supreme Court for the first time, and on review, they ruled in favor of Ashton Barnes and his family. In that unanimous Supreme Court ruling, they held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. They stated that the inquiry into reasonableness of the officer and that force requires analyzing the totality of the circumstances. That analysis demands, in their words, careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis that was used by the Fifth Circuit and instead applied a totality of the circumstances approach. The Supreme Court stated that most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. So the main thrust of that ruling was rejecting the more limited scope of analysis that was applied by the Fifth Circuit, which was the moment of threat analysis. Instead, the Supreme Court ordered that the lower courts need to look at the full picture before, during, and potentially after an incident. Now, after the Supreme Court issued that ruling, the case went back down to the Fifth Circuit for re-review to reapply that correct analysis and look at the totality of the circumstances approach. Now, interestingly, the panel in the Fifth Circuit did not hold oral arguments in this case or ask for additional briefs in light of what the Supreme Court said in that new ruling. Instead, they just re-ruled on the case on their own. In the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight creates a deadly threat and that the officer here reasonably used lethal force to prevent a dangerous chase. Because of that quick new decision without additional arguments or briefs, Ashton Barnes' attorneys and his mother then once again sought immediate Supreme Court review. The petition argued that this new ruling actually contradicts what the Supreme Court just said. After the case was distributed for conference and after the respondents waived their right to actually respond to the Supreme Court actually denied review to this case. So that means that the court will not take up Ashton Barnes' new second emergency review, and instead the Fifth Circuit lower court ruling that allegedly reapplied the Supreme Court's new analysis will now stand. So what does this actually tell us? Well, first, this is not a decision on the merits. The Supreme Court is not saying that the Fifth Circuit got it right. It's simply choosing not to step in once again at this stage. Second, the Fifth Circuit ruling now actually stands, and that means that the risk of flight reasoning that was used by the Fifth Circuit currently remains in place and potentially is precedent in that circuit court and could potentially be cited by other circuit courts as well. And third, this follows a pattern that we've been seeing, just like in some of the Peterson suppressor cases and other cases. When a court does not request a response before conference, a denial often comes immediately after that, and that's what happened in this Supreme Court case. Now, here's one of the big takeaways with this whole case and the denial. The denial has some very important implications. So first, it leaves unresolved tension between what the Supreme Court said in that 9-0 ruling and how the Fifth Circuit applied that ruling on remand. Second, it allows lower courts, at least for now, to continue developing how the totality of the circumstances test applies in these real-world cases like this one. And third, it means that this issue may come back to the Supreme Court eventually later, but likely in a different case with a cleaner record or potentially a stronger conflict. It could be that the Supreme Court looked at the facts here in this case and they believe still under the totality of the circumstances that the individual would lose this case, and maybe that's why they denied review. So this is where this case currently stands, this Barnes versus Felix case. We had a unanimous Supreme Court ruling saying that the totality of the circumstances approach is the correct analysis. They struck down the moment of threat doctrine that was used by the Fifth Circuit. And then you had a Fifth Circuit decision that arguably pushed back using a different rationale to actually uphold the decision. And now the Supreme Court has declined to step in and re-review this issue, which means that for now that Fifth Circuit ruling will stand, and that risk of flight doctrine potentially is still binding precedent in the Fifth Circuit and can trickle into the lower courts and potentially other circuits as well. So that is what has happened in this critical Fourth Amendment case. As more cases develop, as this potentially trickles into other cases, other circuit courts, and other fact patterns, I will let you guys know. But if you like this type of video and you like this type of content and you want to get updates and videos going forward, make sure you like, comment, subscribe, and turn on all notifications to make sure you never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.